I suppose the lockdown, March 2020, offered unprecedented opportunities to businesses to move to a situation where people work from home on a very large scale. And I suppose, you know, starting in my working time, a situation like that hasn't arisen before, but it has allowed, if you like, a mass kind of experiment in how can this work? Can it work? And I think it'd be fair to say that many businesses were pleasantly surprised that things that would have, you know, a month ago seemed unthinkable actually could work. And in that context, a lot of businesses are reconsidering their organizational needs post-lockdown, and they're looking at whether or not this is something that can form part of the working life going forward. And similarly, employees they've maybe now had a year and a half, possibly more, of working in a very different way of going on, and they are increasingly saying, well, you know, do I have to go back to full-time working in the physical office space, or can I have a flexible working pattern of some kind? So the relatively new term, and we've had a lot of new terms, you know, in the past couple of years, between furlough and lots of other different concepts that we haven't previously engaged with. The relatively new term of hybrid working has come into vogue very much, and I mean, the airwaves are full of it day after day. Some, I would venture to suggest, perhaps a majority of employers where it can be facilitated. Obviously, if you're a mechanic, I mean, you know, working in a large garage, you're unlikely to be able to work from home. You know, if you're a lorry driver, you're not going to be working from home. But where it can be facilitated, I think probably the preponderance of employers see that in a controlled way, it can bring benefits. And I'll talk a bit about those. But there are also risks and things to be taken into account. And I suppose if there was any takeaway from what we are saying this afternoon, what we would urge people to do is to, as far as possible, continue to let the situation evolve. Things are changing weekly, daily, and therefore it's probably not the time to get into hard and fast, immovable, inflexible scenarios, because something had happened 2 months down the line, and that isn't a good idea after all. And to keep engaging and speaking with your employees as the entire situation is worked out. So hybrid working, what is it? Well, it's defined as a type of flexible working where time is split between the workplace and a remote location, generally speaking, people's homes. And as I've referenced, the executive is now saying, if you can work at home, you should. You know, that's because of the current concern around the variant. But I suppose for everyone, you need to take that message to heart, and then you need to think in particular about your vulnerable employees. If you have folks who are clinically extremely vulnerable, you need to take a careful think about that. You need to think about pregnant employees in this kind of situation. So, as I say, our advice would be to allow things to evolve so that difficulties that might arise can be talked through, ironed out. I mean, there are very few difficulties that can't be eliminated or certainly reduced. And the best thing we find is to allow a degree of flexibility. Obviously, not one that, you know, unduly negatively impacts on the business, but allow a degree of flexibility to the end that you can see what works, what doesn't work. Many employees, I said that the majority of employers, and I'm just speaking from my personal interaction with them, seem to be reasonably favourably disposed to it. Employees, by the same token, are generally speaking reasonably favourably disposed towards a hybrid working policy. But in appreciating benefits from of working from home, they also do appreciate and express this a lot, that there that there are benefits that can't be replicated by working from home. The interaction, the sounding off of ideas with each other, all that sort of thing is missed out on if you're working from home full time. But one thing to consider in all of this interchange and exchange of ideas with employees is the idea of a hybrid working arrangement, is a working from home policy, because there are quite a few things that you're going to have to take into account to fulfill an employer's obligations with regard to providing a safe working environment. If the working environment is now home, you're going to have to take steps to ensure that, in fact, that is a safe working environment. And as I say, the Labour Relations Agency has produced very helpful guidance in this regard. I always say, why reinvent the wheel if an expert organisation has put something together? But it shouldn't be rigidly adhered to. It's a template that you can bring into your organisation and you can see, does it fit? It certainly will have the critical core elements that you would need, and then you will look and see whether there are particular aspects that need to be revised because of the particular circumstances in your particular business. But what you definitely need to do is engage and consult, including with employees. If there are employee representatives or unions involved, obviously there are requirements to engage with them. With managers, they will be the people on the ground knowing what's working and what's not working. And then you're going to have to consider, in the context of hybrid working, as I say, the location, does it conform to the basic standards of safety? What are the insurance arrangements around it? What are the arrangements for ensuring employee wellness and inclusivity? People are working remotely long periods of time. Is there proper engagement? I mean, there can be issues around isolation and so forth. As I say, we would suggest trialing is a good opportunity to and should be used for that purpose. Now, in saying all of that, if an employee has determined, well, I've now got an arrangement that suits me, and I want to move to this on a full-time basis, an employee who satisfies the relevant criteria, which would be that they have 26 weeks have been working for 26 weeks with you, have a statutory right to request what's known as a flexible working arrangement. And that could be any number of things. It could be term time working for mothers with children, or fathers for that matter. More likely to be, experience tells us, is more likely to be females. It could be part-time, it could be shorter hours, it could be what are called compressed hours, doing the same number of hours but a shorter number of days. And individuals have a statutory right to make a request. Now, it's important to know that the right is to make the request, and the entitlement is to have that request considered in a formal way and to receive a formal decision. It is not an entitlement to get a flexible working arrangement. So an employee can't say, I require a flexible working arrangement. Here's what I require, and I want to know when it's going to be implemented. That is not the right. The right is to make the request and have it considered. Even someone without 26 weeks could still make the request. It's just that they don't have the statutory entitlement. Generally speaking, it's probably appropriate to deal with requests from anyone in the same way. The employer's duty is to consider that request and decide, can that amended working arrangement be accommodated within the needs of the business? So the employer will know his or her business. They will know what can and can't be achieved. They will know that, someone who says, I want to work only the times from, this would be a ridiculous example, but who pick an arrangement that they know means that they won't be there when the business is at its busiest or whatever, that's not going to be able to be accommodated. And it is entirely legitimate for business to say that can't be accommodated. But what's important is that each application is objectively considered on its own individual merits. It's very important that employers don't respond with a knee-jerk reaction of that just wouldn't work. No, we've never had that. We can, nor to say, well, no, because if I give it to you, everybody's looking for it. Those sort of responses don't help and are the sort of responses that are liable to lead on to further complications. Now, I've set out there in some detail, probably not all of it required to be gone into, but there is an actual formal format that has to be followed. So the written request comes in, you must hold a meeting within a certain period of time, 28 days. You must allow the employee to be accompanied by a statutory companion. You must then write and convey your response, to the consideration within 14 days of the date of the meeting, and the employee can appeal that outcome. And again, that outcome should be communicated to them within 14 days. And if you've decided that you will accept the request, then you would be writing to the employee, setting out the terms of the new working pattern, stipulating the date when it's going to take effect from, and that a new agreement, if you like, must be dated. And that's now a permanent change. That's a permanent change going forward. So, and that's important. That's a formal amendment to the working arrangement, and it's permanent going forward. If you're going to reject it, then you have to set out the business grounds. It's not adequate or appropriate or sufficient just to say it couldn't be done. You're going to have to set out the reasons why. But again, you will know your business, and it's entirely legitimate for you to say, knowing your business, we can't offer it on this or that or the other ground. As I say, you have to provide sufficient explanation. You have to let them know, that the employee, that is, of their right to appeal. And the business grounds which are identified as being legitimate on which you could reject such a request are if it produced a burden of additional costs, if there was a detrimental effect on ability to meet customer demand, so if it meant that the business was empty on a particular day and it's a customer-facing, customer-engaged business. If it can't be reorganised among existing staff, sometimes applicants for flexible working arrangements go out themselves and canvass other employees and say, look, would you mind if I came an hour later to work or whatever, whatever it is, and find that, their colleagues say that's fine. May not suit existing staff. If it were something like seeking a job share, and it was just an impossibility to get someone else to be the job share partner, that would be a difficulty. And obviously, if there's going to be a detrimental impact on quality or indeed on performance, or really harking back to the example I was giving, if the employee is seeking to work only when there's actually low levels of work going on and wanting to be absent when there are high levels of work, that wouldn't work either. Or if there were planned structural changes within the business completely unrelated to this flexible working arrangement, but the effect of which would be that it couldn't be accommodated, that also can be that also is a legitimate ground. So as I say, to sum up then, we have this move towards hybrid working arrangements. For the most part, those that are proceeding informally at the minute. We would see not that many formal requests for flexible working arrangements, because I suppose people are at the time of working out, is this good for me, and so forth. But we would anticipate that there will be more flexible working requests going forward, and finish off by saying that whereas previously, for example, an employers would say, you can do a job from home. Well, lots of jobs we find now can be done from home. So, there has to be a more thought through response than that. But I will now hand over to Leanne, who will deal with changes to contracts of employment, which is another issue that comes up time and time again.
Hello, everybody. I'm Leanne Murphy. I'm a solicitor here at Rosemary Connolly Solicitors. So as Rosemary says, I'll take you through our next slide, which is on changes to contracts of employment. So since the outbreak of COVID-19, we've often been consulted in recent times from employers like yourselves who are looking to make changes to the contracts of employment of their employees for a number of different reasons, in that their business needs have changed as a result of the pandemic. We've also been consulted by a number of, I would say, small to medium-sized businesses who haven't actually got a written contract of employment in place with their employees. If you are such a business, I would strongly encourage you to get a written statement of main terms and conditions of employment drafted. Seek legal advice on that to ensure that it meets your needs. Because employers do have a legal obligation to provide their employees with a written statement of main terms and conditions of employment within 12 weeks of that employee starting work with them. So that's something to be mindful of, because there could be legal implications for an employer if they fail to do that. So employers may wish to negotiate and agree changes to the terms and conditions of contracts of employment for a number of different reasons, as I've said. Some of the most common that we have been consulted on in recent times have been, for example, including a working from home clause or a hybrid working clause. And Rosemary has gone through that with you in detail, so I will not go over that again. Another very common one at the present and is in the forefront of a lot of employers' minds is a clause for temporary layoff and short-time working. The reason being that when the pandemic initially hit, employers were faced with a situation whereby suddenly they didn't have work available for their employers for one reason or their employees, apologies, for one reason or another. But the government had not yet put in place any schemes of assistance for them. And a lot of employers were facing what they thought at that time was an immediate redundancy situation. So a temporary layoff clause or short-time working clause within your contract is the right to place your employees on temporary unpaid layoff or short-time working, which is reducing their hours or their days that they work on a temporary basis. There is no limit to how long you can place employees on temporary layoff or short-time working, but it is important to note that after 4 weeks of continuously being on temporary layoff, or I think if they are on temporary layoff or short-time working for 6 weeks within a 13-week period as well, the employee is entitled to request redundancy. However, it does give you that period of time to consider your position going forward and try and obtain new work, and to avoid an immediate knee-jerk redundancy situation reaction, that may have happened. All employees are entitled to during that period is a statutory guarantee payment, which is £30 per day for 5 days in a 3-month period. So it's £150 in total within a 3-month period. Employees they still retain their continuous employment. They're still employees. Their holiday continues to accrue, but that's all they're entitled to be paid during that period of time. Another point that we have been consulted on a lot is changing contractual hours and days worked, again because of restrictions that have been put in place by the executive, earlier closing times for certain industries and things like that. So that's something that people have come to us. So if that's the situation in your business, you may want to take advice about changing the terms and conditions. One thing that all employers must be aware of is that you cannot unilaterally change the terms and conditions of your employees' contract of employment. You have to meaningfully consult with your employees with an attempt to agree those changes with them. If you do proceed to just draft up a new contract, and sit it in front of your employee and tell them to sign it, you would effectively be in breach of contract if you continue if you started a new contractual arrangement with them without their agreement. And that obviously could have very serious legal implications for your business, such as an unfair dismissal claim or a breach of contract claim. So you'd want to avoid that if at all possible. We find more often than not that if you are, open and honest communication with employees is the best way forward. Employment law, we would say, and it's all about reasonableness. And if you can explain to your employees why that need has arisen and why, you know, this change is now needed, more often than not, you can obtain their agreement. If they're, you know, if they're hesitant, you know, there may be some negotiation that's involved. You know, you may have to, you know, consider other things that you may be able to give them, you know, to take something away. But again, you know, that's all a matter of discussion between yourself and your employee. So that's something to certainly to keep in mind. So I'll move on now onto our next slide, which is regarding the health and safety considerations. So obviously, since the outbreak of COVID, health and safety within the workplace is at the forefront of a lot of employers' minds at present, and you know, it's been given a lot of press coverage and things like that. So what I would say to all employers is, you know, use the guidance, the government, the official guidance that's there. That's what it's for. So the Health and Safety Executive of Northern Ireland, the Public Health Agency, they have developed very useful guidance surrounding health and safety within the workplace. Within that guidance, they've made it clear that employers are required to undertake risk assessments of their workplace to include the risks posed by COVID-19. Now, risk assessments within the workplace, they're nothing new. Employers were always required to undertake a risk assessment within the workplace, but obviously with the developing situation, those assessments have to be reconsidered and adjusted to meet the needs of the business as it is at present. You know, the situation is continuously evolving, as we all know. So those risk assessments will require constant review, you know, even sometimes on a monthly basis, to make sure, in line with the current guidance, that you know, that the employers meeting their legal duty towards their employees. So I've outlined a couple of things, you know, that you might want to consider within the risk assessments, but you know, it's really a matter for the individual employers. You know your business. What I will say is that the HSE Northern Ireland, they have a template risk assessment available on their website, which can be adapted to meet the needs of your business. It's very useful, and again, as Rosemary says, you know, why would you change that? That it's there for you. Adapt it and use it, and you know, hopefully you'll not find yourself in a situation you know, where there's any concerns for health and safety. But it's important to know that it is the legal responsibility of the employer to ensure the workplace is a safe environment. So you need to do these things. Employers should also welcome any employees coming forward and highlighting any concerns that they may have in relation to health and safety. They should address any of the concerns as quickly as possible and take them on board. You know, sometimes there can be a bit of a refusal to consider things, and that's when employers really put themselves at risk, because employees could then refuse to attend work on the grounds that they're fearful, you know, for their health and safety. And you know, there has been there is case law coming through now from the employment tribunals, where employees have highlighted a health and safety matter, particularly in relation to COVID-19, and their employers haven't taken that seriously, and they've either dismissed them, or the employee have felt that they're not safe in the workplace, and they have resigned and claimed constructive dismissal. And they don't need to have 12-month service if it's a matter for health and safety. So something to be very mindful of. So I'll move on now to vaccination status. Again, this is a tricky one. It's something that's constantly evolving, but again, it's very relevant to the times that we're living in. So as I've already said, employers have the legal obligation to ensure the workplace is safe and to try and eliminate and control any risks to health and safety within their workplace. So this duty on employers really does give them the justification to encourage employees to be vaccinated. It doesn't give them the right to try and enforce that or put undue pressure on their employees, but certainly encourage them. Some positive ways that you could encourage employees to take up the vaccine is to ensure that you could put up official government information in work, employee areas within the workplace, so that you can be ensured that your employers are getting the actual the correct guidance, because there's a lot of stuff going around that is incorrect. and people are being exposed to that every day. You could also allow, make it known that if an employee needs time off work to attend to get the vaccine, that's something that could be accommodated within the business, and they're useful things to encourage vaccination. Ultimately, however, the decision as to whether somebody's going to get vaccinated or not rests solely, it's the employee's decision. If an employee does say that they're refusing to become vaccinated, you should listen to them. You should take those concerns on board, and you should, if you've determined that the role that they're working in within your business, that really that you would require for them to be vaccinated, then you would need to consider alternatives within the business for them. So perhaps maybe not a public facing role or something like that, but you shouldn't treat them they shouldn't be treated detrimentally. So it shouldn't affect their pay, it shouldn't affect anything like that. You certainly should not take steps to dismiss them, because there is no mandatory, the government haven't advised that vaccination is mandatory, and therefore an employer shouldn't do that either. In relation to vaccination policies, again, the Labour Relations Agency, who are a brilliant organisation for all employers, they have produced guidance in relation to implementing vaccination policies within your workplace, and that guidance makes it very clear that all employers are now encouraged to implement these policies. The guidance they've produced has a sample vaccination policy, which again can be adapted to meet the needs of your business. And that's something that we are regularly reviewing when we're looking at such policies for employers like yourselves. What the guidance makes clear, and it clearly sets out what employers should be doing and should try to be doing, is that the policy should obviously be in writing, as all of your other policies should be. It should be fair and reasonable to your employees, and the decisions and the policy should follow the official government advice, the Department of Health advice in place at the time that the policy is made, and these policies will need to be reviewed again in line with the risk assessment as things evolve. Stick to the Labour Relations Agency guidance and keep the policies under constant review, and you can't really go wrong when you're doing that. So in relation to the final slide here, which is mandatory vaccination policies, now I would, and I think you'll already have gauged from what I've been saying, that we would strongly discourage any employer who's thinking of introducing a mandatory vaccination policy. The government have not outlined any situation whereby anybody would be required to be vaccinated. I know there has been a lot of coverage in the news over the situation over in England, whereby people working within the care industry and care homes are required to be vaccinated now. And I think anybody working on the front line in NHS in England by next April are required to be vaccinated, but that is not the position in Northern Ireland. And as far as I'm aware, there's no such plans in place at the moment to introduce anything like that. I know the executive were consulting about that, but there has been no announcement, and nothing has. There's no reason as to why an employer should be implementing a mandatory vaccination policy. You would be leaving the business very, very vulnerable, in my opinion, if you were to do that without official guidance. The Equality Commission for Northern Ireland have produced guidance in relation to this as well, which I would encourage everybody to download and have a look at. It's called No Jab, No Job. And they look at it from a discrimination background and highlight all of the areas whereby an employer could potentially be discriminating against their employees by implementing such policies. In terms of the vaccination, I know there's certain categories, people in certain categories are not yet approved for vaccination, with certain health conditions and things like that. So you want to be considered in case there's a potential for disability discrimination there. Or I think if it's regards to women who are pregnant, the guidance has changed recently, and they have been advised that they can get the vaccination. But that changed very quickly. So again, there could be a hesitancy there from pregnant employees to get vaccinated, and I think that's reasonable, and the employer should be considering each case individually, rather than having a mass mandatory vaccination policy regardless of the circumstances, because you could be facing a discrimination case, or an unfair constructive dismissal case whereby an employee resigns and claims that they have been unfairly dismissed. So prior to issuing anything like that, you should seek legal advice, certainly. And again, that's the same situation as if you're going to you change the terms and conditions of your your contract to include anything regarding vaccinations. Seek legal advice before taking any action. So that pretty much sums up that final slide there. And this last slide that we have included is a link simply to some of the guidance and things that I myself and Rosemary have referred to during this presentation. And we're more than happy to email them to Tony or to yourselves, for employers to download and have a look at. And as I say, they're very useful. They're official guidance, so make the use of them, certainly.
Thanks, Leanne. So if we could just conclude the presentation by again thanking all of you for your time. And I think what you'll get from us is that the watchword or the or the advice in all of these things is that an employer who acts reasonably, an employer who engages with his or her employees and talks things through and behaves in an open manner is rarely going to find themselves in great difficulty. There's a kind of misconception out there. Sometimes I would get it a lot, employers will say, look, the law's stacked against employers, and employees will come in and say, the law's stacked against employees. And actually, and we've referenced this, employment law is infused with the concept of reasonableness. So and the more you can work towards a situation where it's not a black and white, you say that, I say the opposite, where you've worked constructively in an engaged and reasonable way to achieve a common outcome, and that has to be for the best. Who wants to lose good staff? Nobody does. Who wants to live in a situation of conflict and litigation? Lawyers do, of course. I hasten to add, and obviously we have to get a living as well. But employers, not at all. It's a complete and utter waste of time. So as Leanne has just referenced, there is a lot of excellent free guidance out there from those various agencies. In fact, the LRA and the Equality Commission also have dedicated employer helplines and so forth. I would encourage everyone, use them. That's what they're there for. And for goodness sake, if you have a situation that's proving a bit tricky, take advice in a timely fashion. Advice taken early is likely to be of use to you. Advice taken too late, has a limited kind of engagement. But we're very happy now to take, with the caveat that we're not giving legal advice as such, we're very happy to take any questions or generally have a chat about any